participate in is if we need to put anything on paper first. That's what I need to know first.
What are y'all running by me?
It would be the ISF cognitive track, Your Honor.
Oh, continuing on probation?
Yes, Your Honor.
No. What's next? Y'all read it. I mean, I'm not. You think I wasn't serious the first time? She's been on probation since May. That we're going on 4 years, and I'm getting this report about complete total failure.
Well, Your Honor, I believe
Engages in antisocial criminal behavior, lacks the ability or the desire to be successful on supervision. We have exhausted all avenues of this department. Just, y'all don't have to have an agreement. We're moving forward though on this hearing. Y'all don't have to have an agreement. I'll make the decision.
Your Honor, the state's filing a motion to dismiss in this case, the revocation.
I ordered a motion to be filed. Can you explain to this court why? That you're going to dismiss an order of this court to move forward?
I believe I've discussed with Ms. Campos.
You discussed with this court. I ordered a motion to move forward and to file on this court's probation. You're dismissing this?
Yes, Your Honor.
Denied. Now what? Do I need to appoint a special prosecutor? Why don't y'all think about it? But we're going to move forward. We don't have to move forward today. We don't have to move forward today. But there's reasons why this court orders. And the court expects the order to follow. If y'all don't want to follow it, get a special prosecutor. You don't want to accept the responsibility. But I'm going to follow and give a lot of deference to the probation office and what they say.
And I believe that the ISF was the recommendation of probation, and we agreed to accept that punitive, which it won't be in the long run because it'd be helpful for method of resolving this MTRP.
Right.
Am I misstating?
I've got my own decision. It's my court's it's this court's probation. It's not going to be confounded by an end run. And it's up to this court to decide. Or did the judicial branch lose its authority? I don't think so. Constitution is going to be protected. Everybody takes an oath to do that. Okay. You don't think about it. We can reset this if you want.
Could we have one more short recess, please?
For how long?
5 minutes.
Do you want to come back tomorrow?
Well, I'd like to talk to the prosecutor before I ask for that, but.
What do we have tomorrow?
Docket, initial and then an announcement docket. That's nothing like it was today.
Okay.
Could we just have a couple minutes, Your Honor?
Okay.
And then I think that's the last case for the day on it.
Yeah.
Yeah. Okay.
But do you have to be back tomorrow?
Yes, sir.
Well, why don't we just reset this until tomorrow? Y'all decide.
Oh. Okay.
Okay.
All right.
What time have we set? Well, you can talk to her today.
I'll tell you what we're talking about, and then I'll come back and talk to you.
I'm going to I'm resetting this. Yeah.
One day.
One day till tomorrow.
Okay.
Is that it? That's all.
What's up, people? How we doing? Time served in the house. Major announcement. I am finally getting my surgery. Yana, it's not major. just an old sports hernia from my college football days, and I'm getting old. Because it's getting really bad. And my school's done, so summer break, start off with some surgery. So probably not going to be live tomorrow, definitely over the weekend and Friday. So just look out for the lives. And what's up, people? How we doing? Let's have some fun. I have so many good clips today from all of our favorites. You see on the bottom, Stevens, Bryant, Simpson, DeSanto, and many others. I don't even know what to pick from. That's what happens when you put in the effort. Put in the effort, you get good clips. People will realize that. And it's so funny. So pathetic sometimes. How I've only been in this game for a little while, and everybody watches everything I do and stays on a little couple extra minutes just to dwindle my numbers. But you know what? I don't care if I have 5 loyal people in this room, because this is fun for me. Having fun, and I enjoy being with you people. So no drama for me, people. Let's roll into this. I have phone calls that were fantastic. Poor Judge Perkins. He has such a hard time. How we doing, Trevor? What up, Laura? Richard? How we doing, everybody? Trish, Momster, Grim, Stephanie. If I haven't got to you, I see you. I love you. Let's roll.
I need to get everybody's device muted if I'm not talking to you.
You're kind of going, yeah, you're going in and out a little bit, but I'm not sure what that is.
Thank you, Mark.
This is the city of Detroit versus Eric. For case number SP 145-31831. State your name for the record, sir.
My name is Eric Harbaugh.
Oh boy.
All right. Today is the deadline set for a review.
Yes, Your Honor.
Unfortunately, I have a note here that you were very, very uncooperative, sir.
Okay, I figured that Mr. Phillips would say that. And being that this is a court of law and that this is going to be recorded, that Dennis, the owner of that establishment, is running a scam on the state of Michigan and the 36th District Court. They want to give counseling to people who walk through there and give a psychoanalysis. I didn't go there for a psychoanalysis. They are not certified through the state as a psychiatrist nor as a counselor. Dennis, the owner, is running a scam. So what I did is I went to the greatest place you could do community service, and that's where we worship. I worship at 2 different churches, Holy Redeemer and St. Gabriel's Church. I did 14 hours of community service, and my community actually benefited from it. The scam that Mr. Phillips and Dennis, the owner of that building, are running is egregious on the state of Michigan and the 36th District Court. They're running a scam, period. They could be investigated by the state. They need a prosecutor to go in there undercover and expose the tomfoolery that's going on in that building.
He just said tomfoolery. When have you ever heard tomfoolery in the courtroom? Oh my God, poor Judge Perkins. This was like 8:05 in the morning. He's like his first case.
I sent a photostatic copy of my community's real community service to your secretary, Jamara. She has both copies, one from Holy Redeemer, one from St. Gabriel's Church. I put 14 hours of community service, real community service to my community.
All right. Listen, sir, the court doesn't feel that this is a scam. That you're entitled to your feelings. You agreed to participate in the program and go through there. All right. There was no.
No, I
Wait a
agreed.
minute. I let you speak. Don't talk
Yes,
over.
you did. I beg your
Okay.
pardon, Your Honor. I beg your pardon.
So the court absolutely does not agree with you and your feelings of it being a scam. I think that we've done thousands and thousands of hours of community service, and the community has absolutely benefited from the program. So unfortunately, I'm sorry, I don't know Dennis, I don't know who the owner of the building is, but I certainly know Mr. Phillips, and I can speak to his integrity and what he's done over there over the years that I've been working with him the last 2 years. So you're definitely entitled to your opinion. I am going to accept these letters of service as
Yes.
that they were completed, but I am going to follow up with Mrs. Fernandez and Mrs. Guzman to confirm that you actually did the service. Now, and I'm not finished, sir.
Yes.
The fact that the reason why I am going to accept these is because both of these parishes are in the Southwest Detroit community where the offense has taken place, and we'll leave it at that. You're definitely entitled to your opinion, but the court does not agree with you. All right.
That's fine, Your Honor, but I stand by my viewpoint, and I think it's factual.
All right, that's, again, you're entitled to your opinion, Mr. Horvath. I'm gonna thank you for your service, and I'm gonna dismiss your case, all right?
Bravo.
Thank you, Your Honor.
All right, have a great day,
Bravo.
sir. Good luck to you.
You too. God bless.
You too.
Oh, that was great. All right, let's get a little Judge
transportation
Brian.
car or if it's something
Oh,
else, Judge.
okay, all right. Well, by the time she get, ma'am, I need you to sit up because we can see all in your chest area. Let's sit up straight. All right. I ain't say spread your arms out. I just said sit up straight. Ma'am, stop doing that. Stop.
Look what she's doing. She's doing the hokey pokey. I can't. Wait, ready?
I ain't say spread your arms out. I just said sit up straight. Ma'am, stop doing that. Stop.
Telling you
Ma'am, stop. I didn't ask you what you were telling me. I'm telling you, you don't need to spread your arms out to tell me that you're sitting up straight. I have eyes. I can see. I know the difference between leaning forward and sitting up straight. Because when you're sitting up straight, then we cannot see what we saw. So if you just follow the instructions, that's all. That's all that's necessary. Okay, I'm ready on Patrick. This is case number
Oh,
214524901, the people of the state of Michigan versus Ashley Patrice Patrick. The defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for final pretrial.
this lady's got a lot of balls coming in here, acting a fool with child abuse. Sickening. And you know how Judge Brian is with child abuse. Just an extra oomph. I mean, every judge, but Judge Bryant likes to lay it heavy.
Conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Ashley Patrick. Ms. Patrick, ma'am, please unmute and tell the judge your full name.
Ashley Patrick.
Full name.
Ashley Patrice Patrick.
Thank you. Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Patrick continues her plea of not guilty, continues her jury demand, Your Honor.
Court is going to continue a not guilty plea. On behalf of Ms. Patrick, set the matter for jury trial. Ms. Ritter, how old is your complaining witness?
At this time, Judge, the complaining witness should be around 14 years old.
He's 15.
Ma'am, please don't. Please exercise your right and my demand that you remain silent.
Oh, because if he was 15, it'd be a lot better that she beat the crap out of him. Allegedly. Welcome, Heather. VIP nerd, Heather. Thank you, darling. Always the sponsor of the Dono clips, Heather and Monkey. And Mark.
The people had the burden to prove a case beyond a reasonable doubt. One of the things the people had the burden to prove is the age of the witness. Miss Ritter, how old is your complaining witness?
So, Judge, looking at the data.
Don't listen to the defendant. Say
I'm not
with your same thing that you said before.
Around 14 years old.
Okay.
Uh-oh. Allison, I think we're getting a poll dedicated to
Let
you.
me see if I can bump a trial that's going on this summer while they're on summer vacation. Miss Stevenson, go to, oh, I already have. Oh, no, Shavonte Jackson took a plea, didn't he?
No, I was just going to suggest that date because that one is going to, the people are
Well, why did I
requesting an
see something
adjournment.
with Shavonte Jackson name on it?
People are requesting an adjournment on that one, to which we have absolutely no objection.
Okay, then what happened with Dawson that came in for a final pretrial on June 1st?
I'm going to ask Mr. Flanagan about that one.
Mr. Flanagan, can you look up? I used to have a jury trial on July 17th with Dawson. They came in for a final pretrial on June 1st. And I didn't update.
Okay, let me.
Do we know what the first name of Dawson is?
Lakaya, I think.
You said who?
Gets Lakiya, I think.
Oh, okay.
I see it. Yes, so it was removed from the calendar July 13th and placed on for a final pretrial June 29th at 9:10.
Okay. So technically they're still on. What are they charged with?
One count of assault or assault and battery.
Mm-hmm. All right. So Ms. Stevenson, just consider that, but I am going to put this case for trial. I'm going to put, I don't think, let me look up and see what I received about Jackson. Miss Ritter, did you send me a request? Did you send me a request to adjourn?
So Judge, I just sent my request for an adjournment yesterday to Sir Clerk in.
Oh yeah, that's what it was. I knew I saw something with Jackson on it. Okay.
So are we on team chocolate or team chips? Remember the clip I showed you that she was all about her chips? I don't know though. I have seen her with chocolate. We all know she's a tea drinker, drinks tea. But we were surprised with Judge Boyd. So let's see what the poll says. So basically the rest of this clip was just setting up the court date. I thought she was going to go more on the tatas, but Miss Patrick covered up those tatas and she didn't get any mad. Did we see the Judge DeSanto argument today? Well, we're gonna see it right now.
He is currently sitting with
this
our
is a
children. He
goodie.
has no what is it called? Technology to zoom into the court.
Sorry for
Okay.
the up and down.
Ms. Lukoff, she had gone to the clerk's office about mold or something, and the clerk's office somehow knew about the eviction proceedings. So I'm not sure. So, Ms. Cuff, how is it that you became aware of today's hearing?
So I was going to the clerk office to see how we could fight this. And that's when they had told me, because I ended up showing her the video footage and the pictures of the mold in our complex and our cracked ceiling that's been cracked. And we complained about it and nothing has happened. And that's when she went in the system and she had even wrote down on a sheet of paper stating that we had a court hearing Wednesday, I believe today's Wednesday, on the 21st at 11 o'clock. And I still have the little sticky note in my vehicle.
Your Honor, a couple things here. First and foremost, this particular individual does not have any standing to even be arguing or responding to our motion. Mr. Maldonado should be here. If he didn't have the technology, then he should have appeared in person. That's number one. Number two, I know that notice was sent from my office, and I think it's a bit suspect. There was a judgment taken on March 3rd, and it just happened this week that they decided that they would come to the court and ask about mold. Anyways, neither here nor there, there is notice. So there hasn't been rent paid in over a year. Judgment was entered on March 3rd for $11,000, and it was a consent judgment, Your Honor, $11,398.56. If this property is so horrible, I'm still scratching my head while they are still there. But in any event, I'm just asking for an order of eviction to be entered immediately at this point.
Okay, Ms. Cuff, when did you when did you provide notice?
Okay, so we have been
excuse me, just one moment. Let me finish my question.
Okay.
When did you provide notice to the landlord or to Ms. Lukoff regarding any alleged mold?
I didn't even know I was supposed to send anything over to Ms. Lukoff. I've never been in this situation before. I don't even know who she is. And secondly, we definitely have proof that we have contacted this complex for over a year about the mold. And I have footage of when it started growing and before, and work orders that were put in and were never handled. Thank you very much for that.
Your
situation.
Honor, this is a motion for entry of order of eviction.
Hold on, stop. I need for both of you to please wait until the other is done before there is any, don't interrupt me before the other one speaks, because my court recorder cannot have a clear and concise record. Ms. Cuff, I do not need you to end the statement with "thank you very much." So my question is this. Ms. Cuff,
yes,
you and Mr. Maldonado entered into a consent judgment. Is that correct?
I have no knowledge of that. He went to court for that. I have no knowledge of that, but I do know he said we had to pay something of $4,000. It was not $11,000.
Okay, well, ma'am, you're listed as
and that was because
excuse me, you're listed as all occupants. Your name is not on the lease. Is that correct?
So you said it is or it is not?
Is your name on the lease?
Yes, it should be.
Ms. Lukoff, do you have a copy of the lease?
I can pull it up, Your Honor. I'm going to object to everything that's happening here. We have a judgment that was signed by the named defendant. She didn't sign the judgment. She has no standing to be making these arguments. I can look and see, but this is post-judgment. She's making arguments pre-judgment. There's a consent judgment that you have for $11,000. No payment has been made in 13 or 14 months. I don't even understand. There's no basis to even have the conversations we're having, mold or anything. This is not a motion to set aside a default judgment and we're looking for a meritorious defense. This is very simply a judgment was entered for $11,000. Nothing's been paid since then. And under the court rule, I had to file this motion. So respectfully, Your Honor, I'm not sure why we're going through these discussions.
Because
She
counsel,
didn't
I'm
sign
trying
the
to make it
judgment.
because counsel, I'm trying to make a valid record to make sure that what I'm going to do is all on the record. That's why.
Okay,
Ms.
but how
Cuff's
would
name
she have
is listed-
standing?
Ms. Cuff's name is listed as a lessee on the lease.
Okay, but she didn't sign the judgment and she wasn't sued. So we're trying to take back possession of the property. She's not named in this action.
Well, then, if she's listed on the lease and why is she not named on the action?
She's an occupant, she's an all occupant, so I guess technically she's named theoretically as an occupant, but she didn't sign the judgment. And we're not required in an in rem proceeding to specifically name, there's no money judgment against her. The only money judgment is against Giulio Maldonado. But again, we're trying to get the property back right now. And again, I feel like respectfully, this is all something that if it was going to be argued, it would have been argued at the time judgment was entered. All we're trying to do is enforce our rights to take the property back. So there's no, I've said what I'm going to say about that.
So I will note that there were maintenance issues that were alleged back in January, but nothing about mold. And in fact, it indicates that Mr. Maldonado was present on March 3rd, consent judgment to enter. There was a money judgment, at least as to Mr. Maldonado. There was a pending SIRA application that was paying a large chunk. And so the money judgment was asked to Mr. Maldonado only. And so, Ms. Lukoff, did your client ever receive any money from SIRA?
No.
I'm sorry. Stop doing that.
So,
What's up, Buddha?
Ms. Cuff, why have you and Mr. Maldonado not relocated?
We haven't been there. We have been living with our friend Lachey to answer her question as to why we were still there. We were not there. We actually did leave because the mold had
question, Ms. Cuff, my question was, why have you not relocated from the property? That was my question.
We put in a couple places, but because I was still working on my credit, I had got denied for our new place, but I just re-put in our application for our new place, which we should get approved because I did get my credit up.
Ms. Lukoff, why was an order of eviction, excuse me, Ms. Cuff. Ms. Lukoff, why was an order of eviction not submitted before May 30th?
It was not, I don't have an answer for that. I don't think that the law requires, it just requires a motion to be filed if it's not, if it's after.
No, I understand that. I didn't know if there was some ongoing discussion somewhere or something that was,
No.
That there was some other discussion as to why this wasn't entered. And so the court will note that there was a
Am I able to say one thing about the SIRA?
You may say that. That's fine because I'm going to pull something up in just a moment. But,
okay, so with the SIRA, I'm sorry, what were you saying?
Oh, go ahead.
Okay, with the SIRA, we did everything on our end that we were supposed to. SIRA has not sent the money out because they are still waiting for the landlord and the complex to send over the tax documents and to show that we were going to court because of the rent. And they never sent either of those in. And I recently called SIRA again for an update and they also said that.
Ma'am, what did you do? What steps did you take or Mr. Maldonado take to make sure that everything that SIRA needed was complied with? What did you contact the contacts? What did you do?
I did. Yes, I did, and I have proof of that as well. I have screenshots of when I had called the complex and I was repeatedly calling them about it, and they would not answer the phone. We could not get through to them, and I have the screenshots where it shows that I kept calling them repeatedly. I have video footage of me going up to the complex, and nobody was there at the scheduled time of them supposed to be there. We have no emails for anybody up there. When we ask for email, they say they're not allowed to give it out, or they'll send us an email, and that's how we get their email from them. But we have contacted them. We even had Sarah contact the complex, and they could not get a hold of them as well. And the complex also said when I did get a hold of them that they were going to contact Sarah. And our last court date, they said they were sending the information over to Sarah, and they still have not.
Well, Your Honor,
Sarah
Ms. Cuff
also
wasn't
said-
at the last court date.
Ma'am, correct. You were not at the last court date. And ma'am, you understand you do have the right to have legal representation and you're choosing to represent yourself, correct?
This Luckoff is feisty today. 14 months of non-rent will do it to you.
Oh, and that's another, I was not aware of this. I did not get this paper in the
Lies.
mail, and we've been at the apartment when we came back knowing that we had a court date from the clerk, and we've been checking the mail because I have
Hold
it
on,
on my
ma'am.
phone. It shows me when the mail comes.
Sir.
Ma'am, there is a proof of service that was sent on June 9th indicating that today's hearing was on June 21st.
Yes, I found out from the
With the
city clerk and not from the paper.
One chance.
Ma'am, I'm kind of curious how the city clerk knew that you had.
I have no
a motion hearing
idea.
today.
I have no idea. I could go up there and get the name of the lady who told me, but she went in the system. She even wrote it down for me that we had a court date today. She
Okay.
looked it up in the system.
ma'am-
She's the one who told me about our court date.
Ma'am, this was sent via mail. And how did you get the Zoom ID information?
We already had a court date with you guys, so we literally had to go through our messages to find the Zoom link. I have the messages of that as well, where I asked him to go through our messages to find the Zoom link because we don't have the paper. We never received the paper in the mail. I don't know if it went to the leasing office, but we never received the paper.
Your
in
Honor,
our
I
mail.
know that was sent because I sent it.
If
Yes,
it was
it
sent,
was
that is
sent-
okay, but we did not get it in our
Excuse me, Ms.
mailbox, is
Coff,
what I'm
just one
saying.
moment. It was sent via first class mail to your apartment. If you're not staying there, they don't know that. They don't have another address to send it to. So this was mailed out on June 9th.
Yes, and that's the thing, June 9th, and we have our mail. When we will go back and collect the mail. We still have the keys. We just don't sleep there because of the mold. But we never received that paper to our mailbox. I found
Your
out
Honor-
about the court date from the city clerk. I didn't find out from no court paper in the mail, none of that. I went to the city clerk trying to figure out how to fight this case.
Your Honor, this
Okay,
is a
also gave me-
post-judgment motion.
Excuse me. There's nothing to fight at this point, ma'am. There was a consent judgment that was entered. So unless there is a motion before the court regarding that judgment, this court pursuant to court rule, MCR 4.201 L4 is signing the order, is granting the motion and signing the order of eviction. You've been
Okay.
residing at this property for how long without paying any rent?
We haven't been there, ma'am. We were there in the beginning and then we left and lived with our friend Lachey, who my fiance works with because of the mold. We have not been there.
Okay, so you've been occupying, you've had possessory interest of this property without making any payment of rent.
For 14 months. Your Honor, if I may, they're waiting for me in 28
Our lease
District
is not
Court.
14 months, but okay. We have no problem with leaving the complex. We're fine with that because of the amount of mold in there. We have no problem with that. That's okay. It's fine. We can proceed with the eviction if that's what we're going to do. That is fine. I just would like to know if there is a way for me to go back and fight this eviction, or do I have to wait? Or I don't know how that
I
goes.
cannot give you legal advice. I cannot give you legal advice. However, on the judgment, the consent judgment that was received by you and Mr. Maldonado, it says that you are advised you may file a motion for a new trial, a motion to set aside a default judgment or an appeal bond, which must comply with all court rules and must be filed in court by March 13th, 2023. You may want legal help. So that was all in the judgment that you all received. So at this point, you can contact legal representation to see if there's anything else that you may have at your that you may be able to do. But at this point, you have to contact legal assistance if that's what you choose to do, or you can do it on your own, but this court cannot give you legal advice or tell you how to do it.
Okay, that's fine.
Your Honor,
just
can I
would like
log
to know
off? And
how-
I'm sorry to do this, but I think you've
Hold
ruled that
on.
they've
I'm
been
sorry,
waiting
she
for me.
keeps cutting me off, and
Hold
that's
on.
like really rude
Just-
because I have.
Miss Coff, stop, please. Stop, Miss
She's
Luckoff.
cutting me off.
Miss Coff, stop, please. Miss Luckoff, we're almost done, so if the 28th could just wait for just another moment, please. Ms. Coff, what was your question?
I was just trying to see how much time we have so we can move our stuff up.
Well,
Because we
the
haven't
court
been
has
moving
signed
there,
this
but we
judgment.
just have to.
Excuse me, the court has signed this judgment. The court has signed the judgment, and therefore, the plaintiff can have a court officer go and remove the items. However, if you would like to send communication to Ms. Luckoff to let her know when you're moving out, whether it's in the next day or two, so she knows what she's doing on that end as far as having her court officer remove the items, I don't know. So, but the eviction order has been signed, so it's when the plaintiff dispatches the court officer to remove the belongings.
Okay, we will. We just need a week. That's it.
Ma'am,
If
you've had 3 months. You've had 3 months. I don't know that they're giving you a week, but the order has been signed.
Thank you, Your Honor.
Thank you. All right, thank you. Have a good day.
All right. Bye.
Oh, that was a goodie. That was a goodie. Guys, make sure you hit that like. Here we go. Judge Conlin was in his quarters or his bedroom today. He was not in the courtroom. So we're going to go a little Conlin. Yeah, let's go Conlin, and then we'll go Braunlake. Let's go.
Good morning, Your Honor.
Good afternoon, Your Honor. Jonathan Emmons on behalf of the people.
Judge Torshell Feaster, Assistant Public Defender, appearing on behalf of Mr. Michael Roberts. Mr. Roberts, state your name for the record.
Michael Roberts.
All right. So today's the date and time set for both a pretrial and
Did you hear his court clerk didn't shut off her mic?
also, I think we need to go through an arraignment on a conditional release violation.
Yes, Judge, I believe that's accurate. I have not had a chance to speak to Mr. Roberts, but that is my understanding.
All right. Well, Mr. Roberts, you understand that that you're in custody because of the alleged conditional release violation. You understand that, right?
Yeah.
Okay, so it was alleged that you did violate your conditional release. So what we're doing is essentially also at the same time going to schedule or do something with your pretrial. So I'm guessing Mr. Feaster will make some argument regarding bond. I don't know that. But we don't really have the luxury of you two having a breakout room right now because that will delay everything else. So what we do need to do is just kind of go through it. But do you know why you are? I mean, again, do you know what's alleged that you violated?
Yeah, please contact, which is crazy because it was this morning.
Mr. Don't go into any details about what might have occurred, but just acknowledge that you understand why you might be here. Okay?
Okay, Mr. Roberts, again, you don't want to
have
talk about the
crime.
details, but you understand why you're there right now. Okay, so Mr. Feaster, what are we thinking we're going to do? I guess let's talk about the pretrial first. What do we have resolution there? Or are we going to just move forward with the next date or what?
We had a resolution, given the fact that I believe there are, after speaking to Mr. Emmons just moments ago, I believe there are new potential felony charges that may be forthcoming. Given that fact, we can't resolve the current pretrial case with those pending. I'd ask the court to adjourn that pretrial date out at least 3 weeks so we can track the new felony case and then try to get everything wrapped up together if that does come over to circuit court, Your Honor.
All right, Mr. Emmons, does that make sense to you as well?
It does make sense to me, Your Honor. It does look like he was charged with a felony count from the incident that he was arrested for this morning. I believe that he was already arraigned on that and given a PR bond in that case, but obviously he has to deal with our situation here.
Right.
I don't know when the PCC date is.
All right. So, so should we just go to that August 2nd date? That's a month away, and that will kind of you guys can adjourn it if he doesn't have the PCC before that, but otherwise we'll at least be able to check in on that.
Yes, Judge.
Okay. All right. So is there anything else then, Mr. Feaster?
Well, Judge, obviously, in light of the fact that Mr. Roberts does have a personal bond on his new current pending felony charges, I'd ask the court to consider at least a reasonable bond in this matter, if not a personal bond. Mr. Roberts was in a position to try to resolve this matter today, but given these facts, he's gonna have to deal with the court system a little bit longer. So I'd ask Your Honor to consider a reasonable bond. He's not a wealthy person, but I'd ask for a reasonable bond or a personal bond, given the fact that he does have that PR and the new charge, Your Honor.
So I don't really know exactly, what was charged today myself. I mean, I know that the alleged violation, but I guess, Mr. Emmons, what are your thoughts? I mean, is he flight risk? Danger to the community? What are your thoughts on this?
Well, my concern is going to be that it's a form of he's charged with electronic interference and domestic violence. I'm sure that there's going to be a no contact order put in place and a no go to order put in place. So the question that I would have is, where is he going to go, right? And the other issue that that was brought to my attention, in looking at the police report, and I recognize that Mr. Feaster probably doesn't have the police report. He doesn't have that luxury. And I don't want to get too much into the facts of the case, but it was alleged that during the course of the dispatch, one of the children advised that her father took too many pills. So I have to be somewhat worried of some kind of whether there's some substance abuse issues going on. So if the court is inclined to release him, I need to make sure that he's not going to have any contact and that we have a fairly rigorous testing protocol in place.
Craig.
No objection to testing, Your Honor, to make sure Mr. Roberts is going to be able to stay clean. Mr. Roberts, what Mr. Edmonds is asking is, where are you going to be able to go? Because you're not going to be able to go back to the.
See, the thing is, me and my grandma got to move out because I take care of her. It's our house. We've been there for 50 years almost. My grandma has.
All right, Mr. Roberts, is there no contact order with your grandmother?
It's with my.
It's with your who?
The significant other.
Okay, all right. And so you can have no contact with her during this time period, correct?
No, I want to suggest I drug test every week randomly. I don't have money.
Mr. Roberts, all I want to know is, can you have no contact with your significant other?
Oh yeah, I don't need contact.
And can you go back and live with your grandmother right now?
No.
No?
I think he's saying that the grandma lives at that address that he can't go
It's
to.
her house.
Understood. Thank you. Do you have another place you can go, Mr. Roberts? Because judge is not going to let you go if you don't have someplace you can actually go.
I'll go into Traverse City.
What's in Traverse City?
My dad.
You can go to your dad's house.
Oh my God.
Okay. would you be able to appear for your court dates if the court allowed via Zoom from Traverse City?
Put him in a body bag, Michael.
Okay.
Yeah.
All right. All right. Well, Judge, I guess that's the only place he has set up where he could go if the court granted him release now. Otherwise, if the court.
So I have some concerns here. So maybe what we should do is adjourn this a week.
Okay.
And then I would want, I want name, address, what's going to happen. We will have I don't know.
Yeah,
we could even do this on Friday morning if we did it if we moved it to the VOP or the supplemental thing. Like, I am inclined to let him out, but I got to know way more detail than what I'm getting.
Would you mind, if Mr. Edmonds, are you available Friday morning?
Yeah, I'll be here Friday morning. I'm gonna try and go to the sobriety court graduations over at 15.
Somebody will. I'm covering the violators, so somebody will be there. So I'm just saying we could do this at 9 o'clock on Friday morning.
Please.
And that way you'd have a chance to kind of nail down some of these details, and we don't have to wait a week.
Please, thank you, Judge.
All right, so let's adjourn this to Friday morning at 9.
Mr. Roberts, I'm going to come see you.
Doesn't that get out?
Not today. I'm going to come to see you and get some information, and we can talk to Judge about it on Friday morning.
I'm in rehab, and
I understand.
We talked through this in the other
Not now.
court. I know what I'm doing, how I'm doing it, when I'm doing it.
I understand. Judge is going to want you to sit tight until I talk to you. So I'll come see you, and we'll see Judge on Friday morning, okay?
Yeah.
Okay. Thank you, Judge.
All right.
All right, here we go. Okay, so we have a little custody battle going on. This lovely couple.
Modifies father's parenting time.
Ooh.
Court's aware, of course, from pleadings. Mr. Whalen, you now live.
I think these are Mr. and Mrs. Gourd from a place called Fraggle Rock, I suppose. And this is Judge Dozer.
In Columbus, is that correct?
That is correct, sir.
Okay, obviously, it's a 2.5 hour drive each way?
Yes.
Okay. So that's 5 hours per weekend for the children in your car. In any event, the recommendation is as follows. Fellow should have parenting time the third weekend of every month from Friday 7 p.m. to Sunday 7 p.m. If school or social events conflict with father's weekend, fellow should exercise parenting time on a different weekend as parties may agree. The parties shall meet in Findlay, Ohio for the exchanges at the Walmart store on West Trenton Avenue. Both parties shall ensure the children are taken to school-sponsored events during their respective parenting time.
I don't agree to this, Your Honor.
Okay, I'm first of all sharing the recommendation, and then I'll hear from both sides. All right, why don't you proceed first, Mr. Whalen? Obviously, you don't want to lose parenting time, so what is your proposal? Keep in mind, these are young teenagers. I don't know if your 16-year-old daughter, if she has summer employment, but very often, be it 16, 17, they want a summer job. It's pretty hard if they're gone a lot of weekends, and they have friends. So social life is important for young teenagers. And 5 hours at a weekend in the car is quite a bit for young teenagers. You need to be presumably in your touch with those children and know what's in their best interest. So what is your proposal?
My proposal is, since it seems like I'm being stripped away of my week on, week off, I would like to have my children every other weekend.
Okay.
And right now, it seems to be that I'm going to have to do everything in my power to try to change my living arrangements as they are.
Yes, that was the other concern about you. You live in a one-bedroom apartment. There's not adequate sleep ranges for your children. So
resemblance? Yes.
When will that occur? I mean, they should be able. They're not babies. They should be able to sleep in something other than a blow up or on a couch. When do you think you're going to have different arrangements, Mr.
I was gonna get a bed tomorrow, Your Honor. That wasn't the issue. I have no problem getting another bed for the house. That's not a problem. I'll make do with what I have right now.
What's up, monkey?
It just seems to be that there was a lot of accusations brought against me by Ms. Hills and Ms. Kraft, and I'm unable to speak on any of those issues that were brought against me. There was a lot of false accusations brought against me, and I don't feel like I have any say in that.
Oh, absolutely. Now is your time to say it. I don't know what false accusations talk about. All the accusations is the reality is that you've moved. You're in Columbus, Ohio now. It's 2.5 hour drive each way. And further, it's alleged that you're not exercising all the parenting time to which you're entitled. And
I'm trying to
adequate sleep arrangements for the children. Those are valid issues, Mr. Whalen. So I'm not sure what negative allegations you're talking about. But now is your opportunity to provide pro input.
Well, I was reading up.
Bottom line is what's the best interest for your children. Now, does Claire have her own bedroom where you live?
Currently, no, she doesn't. But if that's what I have to do to make it right, then that's what I'll do to make it right. I'll
think about it.
I mean, try to get a 3-bedroom house or apartment or something that I can afford within my means.
Okay. So again, but think about it. The reality is, you got a 16-year-old. Don't you think she wants some privacy?
I understand that, Your Honor.
Okay.
I'm not.
So what's unreasonable about Claire having her own bedroom when she comes to spend the weekend with you?
That wasn't what I was referring to with the accusations. There was other accusations that were brought against me that I don't think Ms. Kraft and Ms. Hills have any right to know about. It's not it's not any of their concern.
I've not heard those allegations
against me.
Mr. Whalen, I've not heard those accusations. I'm just going based on what is in the written pleadings. Written pleadings are that you moved to Columbus, you're not exercising the parenting time to which you're entitled, you don't have adequate sleep arrangements for the children. That's the bottom line.
So, well, there was accusations about food not being in my house either.
Okay, that's of course the court's going to assume you have adequate. I do recall something about your mother having to bring food over. But these are the primary issues as far as the court's concerned. Is number one, Claire, she's 16, she should have her own bedroom. So when is that going to occur? In the fall?
I don't know. Whenever I'm able to find a 3-bedroom house that I can rent that I can afford.
Does she have a summer job? Do you know, Mr. Whalen?
No, she does not. And I don't understand why a child would need a job if they're getting money from child support.
Well, no, that money does not go to the children. That goes to mom to buy groceries and pay the electric bill and things of that nature. I mean, most kids, when they get 16, 17, they want their own little spending money. If they can go see a movie with kids and other friends and so forth. It's there to spend disposable income. It's not, child support does not go into the children's pockets, or okay, so obviously there's more flexibility that children go to school in Monroe County, correct? It's obviously there's more flexibility during the summertime.
Yeah, I have to give it to Dad. He's definitely trying. Definitely. Jody MacD, definitely.
So if I guess my question to the court is if I move back, if I take and pack up my life and move back to Toledo, would there still be a continued issue with my parenting time?
I would think not. I mean, the whole issue is that you've moved 2.5 hours away. Most kids want to spend 2.5 hours every Friday and Sunday in the car.
I moved 2.5 hours away from my job and to better my career.
Okay, well, that's understandable, and that's because you can provide more for your children when you have better income. So the court's not faulting you for Mr. Whalen, but yes, obviously, if you move back to Toledo, that's going to there's going to minimize any reason to modify parenting time. But no one's suggesting you're not a good dad. It's just that when the kids get older, circumstances change. Have they ever complained to you about the 2.5 hours each way in the car?
Not one time.
All right. Okay.
It's never been an issue until recently.
Okay. So current parenting time is week on.
Daylight's lurking. Daylight, thank you for that super thanks through the comments, buddy. Thank you.
1 week off. I guess rather than going back on the weekends, it seems like that should continue, Ms. Kraft and Hills. The only concern this court has is adequate sleep arrangements for the children. And Mr. Hughes and Mr. Whalen, you've not given the court any idea when you're going to be able to get when Claire can have her own bedroom.
If it's meaning to sacrifice my bedroom, she can have my bedroom while she's here.
Very good.
Okay.
And I'll make do with whatever I need, wherever I need to sleep, so that my children have somewhere to sleep, and I'm not worried about myself. How's
All right.
that?
Okay. All right. So, what are you requesting every other weekend? Is that what you're suggesting?
I was originally keeping the schedule the way it was, but unfortunately, Miss Hills and Miss Kraft decided that wasn't good for them. So that's why they brought this issue to the court, and now I'm here in the courtroom with you, letting you know that I'm trying to fight for weekend, every other weekend.
Okay. So what is it you want then for the time being? You want to continue the week on, week off, or are you asking for alternating weekends?
To try to have a relationship with my children. I would like to ask if the courts would suspend my child support so that I have extra money coming in during the summer while they're here week on, week off.
Child support's a separate issue. It's not before the court, Mr. Whalen. We're just talking about parenting time this morning.
Parenting time that I would like to have would be every other weekend. If I can't have the week on, week off schedule the way it was, then if the courts want to petition it, I would prefer to have every other weekend.
All right, Ms. Hills, not unreasonable.
Your Honor, I guess I'm not sure where he's at on the week on, week off, but we do have 16 and 14-year-old children here. We don't have adequate sleeping arrangements. My client was willing to agree to the one weekend a month and be flexible about that as necessary with the kids' school schedules, with the sleeping arrangements being that Mr. Whalen would give up his bedroom so that Clara could have that, and Mr. Whalen and Gage could have sort of a
I'm sorry. I'm for stopping. Bill Rhodes, you're freaking amazing. These two smell like a bowling alley. Comment of the night. Grim usually has it. Bill, you took it.
camp out for one weekend a month in the living room with Gage sleeping on an air mattress. That's what we had discussed. I don't think that is something that's appropriate for a week on, week off schedule throughout the entire summer.
Ms. Hills, I didn't ask for week on, week off.
Mr. Whalen, don't interrupt. After she finishes, I'll let you respond, but don't interrupt, please. I'm sorry, Ms. Hills.
Thank you. In addition, Clara is looking for her first job. She does want to have that spending money that the court talked about. She's been actively searching. Gage, for the last year or two, has had a summer cookie sales business that he's engaged in, which he has a lot of fun with and makes some pocket money for himself also. There are also school activities this summer, like band camp, and I understand one of the recommendations is that the kids will get to their school-related events regardless. But the kids also have friends in the Monroe County area. And what we'd be looking at with week on, week off, or even potentially every other weekend, because Dad said that he works when the kids are down there with him, that the kids would be going to Columbus, where they don't have friends or any sort of social network, to sit in the one-bedroom apartment. So that's certainly not something 14 and 16-year-old kids are going to be very keen about. These kids do love their dad. There's no doubt there's a bond there. They want to see him, but they also want to be able to have their lives and be teenagers during the summer. So we are asking for the one weekend a month as recommended. Certainly, Ms. Kraft is open to the idea of being flexible with the time, if there's some sort of special occasion, to doing some additional time. She did that for Father's Day weekend. It was his Father's Day. It was her weekend. She gave him the entire weekend, despite the concerns regarding the sleeping arrangements. So she's not being inflexible here whatsoever. But given everything just mentioned, we do feel that the one weekend a month is what's appropriate. Certainly if he moves back to Toledo and has an appropriate place for the kids to stay, appropriate sleeping arrangements, that takes all of these issues off the table. I understand he moved for a promotion, he says. That was not our understanding, as we stated in the motion. But at the end of the day, it was his choice to move this distance away from his teenagers. So we're asking the court to adopt the recommendation in its totality.
Ms. Hills, the court have one question. You said Gage is engaged in a home business of cookie making?
Yes.
Okay. Could he not do that in Columbus?
Your
He
Honor.
does it one day a month.
I
He
would
does
just,
it one day a week.
Just
He
a
doesn't
minute.
do it all the
Hold
time.
on. Mr. Well, can you mute Mr.
We're arguing over cookie sales.
Whalen, please? He's interrupting. Mr. Hills, can you answer the court's question? Ms. Kraft, can you just hold it, please? Both of you?
Shut
So,
yeah, it's my
This is
understanding.
something he does at home, correct? Home cooking business. Can he do that in Columbus?
I believe it's a situation where his supplies and his setup are at home, but I don't have the details on that, Judge. I'd have to defer to
Right.
my client on that.
Right.
I have to defer to my client where the cookie cutters, brown sugar, and flour is. Can we have a breakout room, please? Breakout room, Judge.
The court's going to assume he can take those some of those supplies to Columbus. All right, Mr. Whalen.
Mom's shaking her head. Nope. Brown sugar stays here. Nope. Chips Ahoy stays here. Dad has a 1-bedroom. He has a kitchenette. Cannot make the cookies there.
Your response to Mr. Hill's comments?
Nope.
Can I mute him?
He has a cookie business that he does out of wherever it is, the Luna Pier Farmers Market. It's one day every week. It's not 4 or 5 times a day. It's one day a week.
4 or 5 times. 4 or 5 times a day. Who is he? The Keebler elf?
Okay.
He's Mr. Nabisco. Jesus, Dad.
All right. Anything further, Mr.
Living with me the last time when he was week on, week off in the summer, he would make the cookies a couple days before he left, and Miss Kraft or Miss Kraft's mother would go to
Miss Kraft has a paw. That is not a hand. That's a paw.
the sales for him on his behalf.
Your Honor, my client is raising her hand as if she
All right.
wants to add something.
All right, Ms. Kraft.
Okay, this is Gage's 4th summer of this cookie sale. Yes, last summer I had the ability to go and sit for him the weeks that he was with his dad. And Gage would make his cookies ahead of time. I'd have to help him bake them off closer to time, and then I'd take them. The summers before that, he just wouldn't have his cookie booth those weekends, but he was also 11, 12, not quite as important. But yes, he cannot do it in Columbus because he takes part in the Luna Pier Farmers Market that takes on Wednesdays from 3 to 7. He actually is going today. But yes, but it takes him a couple of days to make his cookies, make his product, and then and have it ready for the market on Wednesday afternoons. Yes.
It's a goddamn cookie.
It is only one day a week, but you figure he works about, between the market and the cooking, he makes about 10 hours, which is what most teenagers
Thank you,
his age
monkey.
work anyway, in a job in a store or a restaurant.
All right. Well, it's wonderful. The two of you have an entrepreneur son. That's pretty cool. That he has the initiative to bake and sell cookies at the farmers market. In any event, the court does believe that there is a change of circumstances to warrant a review and modification of parenting time since Dad moved to Columbus in January of 2023. Subsequent to the January 2020 order, which provided week on, week off parenting time during the summer. The court recognizes, obviously, we have some deficiencies in sleeping arrangements. The court also recognizes that these young teenagers, and yes, their friends are in Monroe County, school friends. They don't have the type of school relationships in Columbus, Ohio.
Welcome, Leanne.
Obviously, during the week, Dad's at work. They're just sitting there trying to figure out what to do. So it appears that the weekend, week off parenting time is no longer the best interest of children, but the court does not believe Dad's parenting time should be limited to one weekend. So the court will order that Dad have alternating weekends during the summer months. So actually, it should be more than just summer months. Ms. Hills, any reason why the weekend off should not continue through the school year as well, as long as it doesn't interfere with school activities?
Your Honor, again, it comes down to the sleeping arrangements.
All right. Well, the courts.
I was going to make the sleeping arrangements happen.
Hold on, Mr. Whalen. Mr. Whalen has already indicated he's going to address that. So, as part of this, Mr. Whalen, you're going to make sure that Claire has your bedroom. When she's there, until you can make other things arrangements, Claire will have her own bedroom. So we'll make that as part of the order. So Dad should have plenty of time every alternate weekends. This will be until further order of the court. Fridays at 7, Sundays at 7. If school or social events conflict with the father's weekend, the parties shall discuss a different weekend, but she should have 2 weekends a month. Again, the parties will meet in Findlay, Ohio for the exchanges. Claire will have her own bedroom. And lastly, when do we start this? So when were the last children in Columbus? The last weekend, the last time they were in Columbus, Ms. Hills?
It was Father's Day weekend, so I just past weekend, but that was my client's weekend, correct, Ms. Kraft?
Yes.
So his weekend would be this weekend coming up, Ms. Kraft?
Yes.
Unfortunately, I can't take them this weekend. I would have to be the next paycheck that I get. Should be after the holiday.
And obviously, we're coming up on the 4th of July holiday. Have the parties adopted the court holiday schedule, Ms. Hills? Do you know?
Yes, Your Honor, and we did have a concern about the one-day holidays being appropriate to exercise because of the travel time.
That's a legitimate concern. And 4th of July is just a one-day holiday. So the court will modify the holiday schedule and to exclude the one-day holidays because of the travel distance. So, Dad, you want to start your first weekend, maybe June 30th?
But I would be able to take them the next weekend that I get paid.
Okay, June 30th, a week from Friday?
No, the following.
Oh, well, you could have this weekend.
And unfortunately, I can't take them this weekend.
Okay, when do you want to start then? July 7th?
Funky.
Yeah.
The best. Thank you.
Okay. So you have July 7th and then, of course, July 21st.
Put you up there for
and if, in fact, there's something that comes up, the two of you should communicate regarding what's best for the children. And if you need to alternate a weekend, maybe it's the first and the fourth weekend, if you cannot alternate. So, but the intent of the court is that to be 2 weekends a month.
May I just
be sensitive to the needs of the children, Mr. Whalen. Obviously, they're getting older, and so be sensitive to those things. So try to plan some fun things on the weekends. I'm sorry, Ms. Hills.
I'm sorry to interrupt, Your Honor. I didn't mean to. I just wanted to inquire of my client as to whether those dates worked for her, since we're getting off their usual schedule.
Absolutely. Yep.
That's not the case.
Ms. Kraft.
I've always made the.
Do the weekends that were suggested by Mr. Whalen and the court work for you?
Yes, it would it's okay, because that would go back to, it would actually, the 7th, 8th, and 9th would be his weekend.
Okay, great.
In the schedule that we had. So like right now, that should work.
Okay.
Okay, so July 7th would be Dad's weekend, and then the 21st of July, and alternating weekends thereafter, unless the parties agree to modify that. And the court would suggest to have, if it's feasible, for Gage to bring some of his cooking products, or Mr. Whalen, that would be wonderful. When you're in Columbus, go shopping with them to get the materials, maybe new cookware.
Judge Braunlick is such a nice man. He always has parental suggestions at the end of every hearing. That's rough.
I mean, that's something you should support. It's a pretty cool idea for Gage to be engaged in this. So I think you want to support that.
That
give you a bond.
I have no problem supporting it. It would be, if I could afford it, it would be a whole different story.
Afford what?
Okay.
Come on.
All right. So,
That was
Ms. Barber,
weak.
to modify the recommendation.
Agreed, Dia.
Yeah. What about band camp? Is that like a week-long band camp, or is it a weekend?
It's about 10 days usually, Your Honor.
Do we have the dates, or is that more like in early August?
It's usually mid-August. We'll get the dates for sure here, probably about mid-July.
Okay, so forward that to Mr. Whalen as soon as possible. We get those dates. Because obviously it's important that they're both children involved in band.
No, just Clara, sir, Your Honor.
Okay, all right. So obviously that Clara needs to participate in that band camp, Mr. Whalen.
I don't have any problem with that either.
Okay, all right. Mr. Whalen, do you have any questions?
Who do I need to speak to about having my child support lifted for the summer?
You can go online to get the Front Court's website. You get a petition to modify your child support. If there's been a modification of your income, you can file a motion.
Okay.
And Ms. Hill, is there anything further? Or do you wish to, any other questions for Ms. Kraft?
No, Your Honor.
Okay, here we go. All right, next clip sponsored by our awesome people in the chat that donated this clip to us. And the poll says, after 42 votes, oh, custody dad yelling on the phone. We got it. Yes, 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 yes. Let's do it. All right, here we go. This is also Judge Braunlink. Let's do it.
Mr. Wagner, Spangler, do you understand the recommendation?
Yes, I understand the recommendation, but I do not agree with $630.
Okay, what about the parenting time? Do you agree with
The
the parenting
parenting time is
recommendation?
fine. I'm
Here we go.
100% fine with the parenting time.
Okay, so you need to contact Family County Child Services. Try to do that today. Schedule that intake so that they can start these sessions with you and your child as soon as possible. Likewise, Mrs. Cunningham, you need to do the same thing. Call that agency today and schedule that intake so we can get this reestablished relationship between dad and child. Okay, child support. Your objection. The child support is much established by guidelines, Mr. Spangler. So unless you believe the front of the court's using incorrect income for you or Ms. Cunningham.
It's $630. That's the correct income. But my objection is I have another child, and you guys want me to have a house and a car and my license and all these things, but I'm only making $1,800 a month after taxes.
Oh, sorry, dude. Welcome to the real world.
Okay. Ms. Breyer, have you taken into account that Mr. Spangler is allegedly supporting another child?
Your Honor, yes. The other child was included in the formula.
Okay, so that was included in that formula. So I don't know how to address any further, Mr. Spangler, as long as they got an accurate income. Yes, they are taking into account in the formula that you are supporting another child. That's all relevant. Of course, so unless you want to consult an attorney,
I'm gonna have to because I don't have $630, Your Honor. I don't have it. I would love to help. I understand that that's my obligation as a father. I am not subjecting to that, but I do not have $630.
Did he say subjecting?
Just to give to her. I have another child. I want to get a house. Like I have things that I need too over here. My living situation. I'm living with my girlfriend's parents at the moment, and I'm trying to get my own house. But it's $630. That's one whole check out of my income.
Get another job.
Ms. Sikorsky or Ms. Barr, do either one of you want to respond? Obviously, if parties can agree to a reduced amount, presumably this is what the guidelines provide for based upon their respective incomes.
That's correct, Your Honor. And I think that Ms. Brower recognized the hardship on Mr. Spangler, and that's the reason for her recommendation that the circuit court fund pay for his parenting time sessions.
Mr. Barnes, anything else you want to add in terms of Mr. Spangler's objection to the recommendation? It's is Ms. Cunningham, is she employed full-time, Ms. Skorsky?
She is, Your Honor. She works at Walgreens. She's a pharmacy tech. In fact, she's at work right now. And the childcare, she did change the childcare provider to reduce the expense. And I've attached those affidavits to my objection. It's a legitimate expense that the formula allows. And having children is expensive.
So that appears to be a big part of this childcare expense. And unless unless you have some family members that can provide childcare that you can agree upon, Mr. Spangler, it appears that the court has no alternative but to adopt this recommendation. Perhaps at some point in time, once you can reestablish a relationship with your child, that perhaps you could provide some of that childcare.
Your Honor, I'd be more than happy to supply child care, Your Honor. I'd be happy to see my daughter more than once a week. But I don't get that.
Okay.
I don't get that. You guys are punishing me for something I had no control over. I didn't see my child for a year because of her. It was not because of me. I've reached out multiple times. She was not able or willing to leave the child with me, even though I was with her in her life for 1 year.
Well, Mr. Spangler, that's when you should have filed a complaint in front of the court, and if you were being denied parenting time. But that's it looks like there was a judgment of support entered in February 2023 that referred the issue
because
yeah. Well, you could have taken the initiative too and filed a complaint of your own for custody and parenting time, Mr. Spangler. But the reality is, the matter was brought before the court at the initial of Mrs. Cunningham, and the issue of parenting time was referred in front of the court for an investigation recommendation. Mom objected to that recommendation, and yes, you could have taken more steps to enforce your rights as a father to parenting time. But in any event, we want to reestablish a relationship between you and your child, and with this recommendation, you will establish that. Hopefully, we can expand parenting time. We come back in August. In the meantime, you can look at talk with Ms. Cunningham about other daycare providers that you're both comfortable with.
Your Honor, I don't even. This is the thing. Like you say, talk to her, and I understand that. I get that concept of talking, but there is no talking.
Well,
okay, there is no talking.
So to bring a child into this world, so you need to start talking now, because otherwise, for the next 17 years, you're gonna have issues. And your child will be
adversely affected by that. I'm gonna have to get a lawyer. We'll have to go from there, Your Honor.
Have the parties completed the SMA program?
I don't believe it's ever been ordered, but if Your Honor orders it, my client will comply.
Yep. All right, Ms. Cunningham, Mr. Spangler, of course, going to add to this recommendation that the parties shall complete the SMA program. It's the acronym SMILE. It's will help you co-parent and communicate, which is critical for the welfare of your daughter. So complete that program before we come back, Mr. Spangler. And again, as you get more time with your daughter, we can address this the child care issue. That seems to be the biggest component of this child support recommendation is child care.
So what am I supposed to do to August? Just pay out $630? Like,
hey, Polly, can you email that to me?
I would suggest, yes, you do that, or if you don't like it, then at least consult an attorney. You don't need to hire a lawyer, but at least consult a lawyer. I
didn't know I was going to get railroaded, or I would have brought an attorney. I would have went and got an attorney. I thought this was going to be a civil, peaceful case, how it went down, how it went in Wayne County courts. But you guys do not run nothing like Wayne County courts.
This is Monroe County. I think we pay more attention to federal court cases in Monroe County than we do in Wayne County because the numbers are so huge. But you can always review with an attorney this child support amount, and the biggest component appears to be child care. And if your attorney believes there's some basis to challenge it, you can always file a motion to modify child support, Mr. Spangler.
Okay.
So in any event, the court will adopt the recommendation with the one additional provision that both parties shall complete the SMA program. Again, both of you should contact Family Counseling and Child Services today, schedule that intake. You each pay your own intake fee, but the circuit court fund will pay for the visits. And that will save you that expense, Mr. Spangler. We'll see you back on August 23rd at 2 p.m. So review the issue of child support
How do I
attorney in the
pay?
meantime.
How do I
sorry?
pay? When does the paying start?
Your Honor, I'll submit
well-
a uniform child support order so that the front of the court can send out an income withholding notice.
The child support begins May 1st, 2023, Mr. Spangler, and you need to pay it directly until you see it coming out of your paycheck.
It's not going to come out of my paycheck. I will pay you guys. You guys ain't going to come in here and duck my pay like that. Like, that's crazy, man. Why can't you give me the option to pay it?
Okay. That's just the way the state guidelines require that be paid by income withholding. So that it'll eventually catch up, but until you see it coming out of your paycheck, you need to pay it directly. And do talk to an attorney if you disagree with the child support.
Yeah, I
amount.
will.
All right.
I will.
We'll see you back on August
Have a good one.
23rd.
Yeah.
Right. That will conclude this hearing.
Thank you, Your
Anything
Honor.
further, Mr. Gorski?
Thank you.
All right, the court will adopt the recommendation. That will conclude this hearing. You can all zoom out. Thank you, Ms. Brower.
Your Honor, that new recommendation regarding SMILE program is in your queue.
Wow. Dad was a jizzerk. All right, people. Thank you so much. Thank you for the wishes for tomorrow. Everything's going to go good. I am not worried about it. Wifey is going to take care of me. We all know that. Thank you for everything. Polly, can you email me that link? I missed that clip. Dying to see that. I put my email in the chat. Also, you can find it on my channel. Guys, thank you so much. Go check out my girl, KCC Kitch. She's taking care of business. Let's get rocking and rolling. I will see you soon. I am Phil. This is time, and you have been served.